And we are the Coalition, loud and proud, outrage porn-free, civilly disobedient media broadcasting live on the worldwide Coalition Radio Network at coalitionradionetwork.com, facebook.com/the Coalition Radio, on the mighty Twitter at coalition_radio, and of course the original, the mothership, at coalitionradio.us, where 7 years of Coalition 1.0 and 2.0 interviews and stories and tales from the crypt, it's all there. Well, if we couldn't make this week more hectic, insane, the Ninth Circuit Court today decided in all its wisdom to drop what appears to many to be some type of bomb into the midst of your right to bear arms and your right to self-defense. Joining us tonight is someone who is officially, as of now, a repeat offender at the Coalition Talk Radio. Calenda was born and raised in Rhode Island. He's always heard the call for public service. Following his graduation from the University of Miami School of Law in 2006, Chas was hired as a special assistant attorney general at your Rhode Island Office of the Attorney General, a position which he held until 2018. During his tenure as a state prosecutor, Chas developed a reputation as a firm yet practical and fair prosecutor amongst his fellow members of the bar. He had the opportunity to try dozens of cases to juries and judges in Rhode Island, Little Rhodey, state courts, all levels, and to this day continues to be well known for his independent streak, both inside the office and since leaving the office. He's in private practice right now at the law firm of Inman Tourgee, I hope I pronounced that right, in scenic, metropolitan, the Paris of Rhode Island, Coventry, Rhode Island. Chas, welcome back to the Coalition. Thanks for joining us on short notice. While the other radio stations in town are replaying turgid diatribes from some guy with a nerdy voice, whatever, talking about some form of outrage porn, we are bleeding edge here. And I appreciate you willing to lend your voice to what is superficially controversial. I'm sure when we get deep into it, it'll even be worse. So thank you for joining us.
No problem. Glad to be back on the Coalition.
Well, so let's start, and I'm referring to a website called Courthouse News. All right. Carrying guns in public is not a constitutional right, the Ninth Circuit rules. Now, since we posted your appearance, not only has it generated significant excitement amongst the 2A community, for which you are an important member, but it's also yielded a whole lot of nicknames for the Ninth Circuit. My favorite being the Ninth Circus. A prominent libertarian in the state refers to it. So let's kind of first do a little bit of a primer in federal courts and sort of start from the beginning and then sort of wind our way through this to what we understand to be the situation now, recognizing that this is breaking news and folks given the opportunity to reflect on this in the next day or two, we'll come up with additional perspectives, which we will be happy to call you in the middle of the night and ask you to join us live again for. I guess that's what we do here. So first of all, just to explain, how do federal courts, what's the process? Somebody's pissed, they take a claim to court. It's deemed federal, and that's the starting point. Where do we go from there?
So assuming you have a federal claim, you can bring your case within the federal district court that encompasses your area. So in this case, the case you've been referring to originated out of Hawaii. That falls within the Ninth Circuit. And there is a U.S. district court in Hawaii, or that hears the original claims. It's a trial court. The U.S. district court for the District of Hawaii would hear these claims, and they would render a judgment or some sort of preliminary judgment, which is then appealable to a circuit court. And that, as I mentioned, is the Ninth Circuit in the case of Hawaii. And the circuit court has two layers. They usually hear cases on a panel basis, which usually consists of 3 judges, which the majority rules in that situation, or they can hear them en banc, which is a larger panel, or it could be the entire panel of judges sitting in that particular circuit, which can overrule the smaller panel. And then that en banc panel is usually the last say unless the U.S. Supreme Court gets involved. How long does this process typically take? I mean, this can,
I would imagine a determination like this is going to be SCOTUS bound, as they would say. Is that a fair assessment, or do we all just overreact to how much is actually going to go to the Supreme Court?
I always think there's always an overreaction on every level. If you look at any media level about which cases are going to make it to the Supreme Court and which ones aren't. But this one has one of the signature issues involved that usually gets the Supreme Court involved, and that's a split between the circuits on the issue. The Seventh Circuit and the D.C. Circuit Courts of Appeals have held differently than the Ninth Circuit and other circuits on this particular issue as to whether or not the Second Amendment covers the right to bear arms outside the home, which is what this court particularly ruled on in this case. So when there's a split amongst the circuits, it is more likely that the U.S. Supreme Court will grant certiorari, which is a discretionary petition, to review the decision of the Circuit Court of Appeals.
So the case itself, what are I hope you had an opportunity to sort of familiarize yourself with the case. How did this all start?
Well, it looks like it started quite some time ago, maybe back in 2011, when this gentleman tried to apply for a permit in Hawaii, a permit to carry in this case, it looks like an open carry permit. Hawaii apparently has statutes that govern open carry and concealed carry. But this gentleman tried to apply apparently for an open carry permit. Hawaii law requires that you have an extraordinary need to be granted that permit under their statutes, and he was denied twice. So he did not appeal within the state courts. He brought a federal claim, basically a civil rights claim in federal court to challenge the ruling, challenge a statute on their face as being violative of the Second Amendment. And he brought some other ancillary claims along with it, which were essentially abandoned. But he challenged it facially, according to this court, and saying that the statute broadly infringes upon the rights conferred by the Second Amendment.
This seems, if you're not an expert, but like me, you try to play one on the radio, this seems to be a sort of a bolt from the blue. Can you try and put this in perspective for us?
I mean, this decision, the Ninth Circuit covers mostly all the Western states. So you've got like Hawaii, California, Nevada, Arizona, those kind of areas. So this is only really binding on them, but no doubt, states are looking at this decision that are not necessarily covered by it, but will want to implement the reasoning behind the majority opinion here. And one of those states is Rhode Island, because on brief for the state of Hawaii was none other than our Attorney General Peter Norona in his capacity as Attorney General for the state of Rhode Island, defending Hawaii's ability to essentially deny permits to everybody except those with an extraordinary need. That's
okay. Now they usually call this an amicus brief, right? This is a quote unquote friend of the court brief that he filed.
Yes, he amongst several other states. He was obviously not the only one, but they seemed to all have in common. They were on the left side of the spectrum that were defending the state of Hawaii, and the states on the right side of the spectrum were on amicus brief, defending the plaintiff in this particular matter.
All right, so that to me that's stunning, because in a state where, as we like to say, in the halls of justice, justice is often found in the halls. I would imagine filing a brief like this is not just a casual Saturday afternoon spent, is it? You don't do this while watching the Golf Channel. I'm thinking.
No, you are not. You are not filing and writing and making sure that your brief conforms to all the strict mandates in the Court of Appeal, Federal Court of Appeals, while you're watching golf on a Saturday afternoon.
So despite, and I'll put this in a political sense for a second, even though we're really calling upon you as an attorney tonight, in a very real sense, despite overwhelming support of the Second Amendment by the citizens of the state of Rhode Island, as evidenced this past week, we had Brenda Jacob on and we had Jen Moffitt on from the variety of two-way protection groups in the state, where Ms. Jacob mentioned that at one point, before the server crashed, they had sent over 16,000 emails opposing, if you will, restrictions on the right to bear arms and the restrictions on the natural right to engage in one's self-defense. Did he actually use state resources for this?
I'm almost positive. I can't imagine he wouldn't. He has people in his appellate unit that are probably writing this brief. I can probably say with fair degree of certainty, Peter Nerona did not write the brief himself. Mm-hmm. He's got some very talented attorneys in his appellate division who probably practice in federal court quite regularly who are writing these briefs for him.
And I don't want to obsess over this one notion that we've got state resources going out to support what is clearly a political claim in direct opposition to the will of the citizenry. But is it really? Am I oversimplifying? Is it just that?
You're not oversimplifying it. I just don't know what the need for Rhode Island was to weigh in on this, other than Peter Nerona has similar powers in his ability to issue a permit from the Attorney General's office here in Rhode Island that he probably wants to protect. And it's quite obvious that is his goal because he's a supporter of one of the current bills that's pending in the Rhode Island Senate to take away the ability of the police chiefs to issue permits which are issued on a shall issue basis, as opposed to the Attorney General's permits, which are may issue if you can show need to have one. And Peter Nerona has yet to find a need that he seems to like, according to my clients and other clients that I've certainly seen cases go before his office to try to get a permit.
So the crux of the matter legally, and again, feel free to jump in and correct, here is that the Ninth Circuit Court, I should say, has decided that the ability to open carry is based on a needs basis, and that the Constitution, despite I'll call it mine and many others, every man's interpretation, it does not specifically guarantee the right to carry weapons. I'm baffled. How do they arrive at that?
Well, if you, I did not have a chance to read every page of that decision, but most of that decision was based in what I would consider ancient history. They went back all the way to the 1200s in English history to try to determine that this the right to bear arms outside the house is not one that's covered by the Second Amendment, and to arrive at their ultimate decision. Now, you look at the text of the Second Amendment, the right to keep and bear arms, and you look at that in context of what the U.S. Supreme Court has already decided in Heller. I don't know how they square that, because the right to self-defense does not merely exist within your own home. And the Ninth Circuit has already ruled previously in the case of Peruta versus County of San Diego, and that happened in 2016. Ninth Circuit has already ruled the Second Amendment does not give you a right to bear arms in a concealed fashion either. So today they just clarified and made the whole thing and finished up the entire analysis and said, not only do you not have a right to bear arms in a concealed fashion outside your home, you don't have a right to bear arms in an open fashion outside your home. So they've essentially eliminated the words bear arms in the Second Amendment. I don't know how that works. That goes against everything I've learned about how you interpret constitutional law.
I'm assuming that the appointees to this court are seasoned jurists. Is that, and I'm not being facetious here, even though we've had, I don't know, it's seemingly in Rhode Island, anyone can be a judge, but sorry, had to say that. How do you openly conflict with established law, if you will, established Supreme Court-based law? How does that work?
Well, my biggest problem was when the Supreme Court ruled that the right to keep a firearm in your home for self-protection was a fundamental right, and it applied to the states. When they did that approximately 10 years ago, the people who don't find the right to bear arms as a Second Amendment right harp on the language that Justice Scalia used in his majority opinion. And that language was, the right is not unlimited. You can't do it at any time, at any point, for whatever reason you want. Certain long-standing prohibitions could be constitutional, but they leave out the most important part of what he said. What he said was, he used the examples of, like, barring convicted felons, barring drug addicts, barring people who abuse alcohol on a consistent basis. Those are restrictions which Justice Scalia had said in his majority opinion, said those could still be constitutional. But they use those words to say, well, that was a very narrow holding. It only applied to inside the house, and everything else essentially is a constitutional, any other restriction would essentially be constitutional. That's not what Heller says. But Heller did leave enough room to argue amongst the circuits, obviously, because there is a split. They did leave enough room where people were able to kind of put words in the justice's mouth.
So let's go back, dial back, if you will, for a moment to the applicability of this. My superficial reading tells me that right now this case law only applies at a certain level in the 9th District. Is that correct?
Yes, it applies to any state. It's binding within any state within the 9th Circuit, which is, for the most part, the West Coast, and
right.
Just inwards.
Right. Are there cases like this that you're aware of, and this is a very open-ended question, that have particular, just to say, the same type of particular impact here in Rhode Island as far as where federal court is, and how potentially could an activist AG like Mr. Nerona, who doesn't seem to have a lot of time to deal with some of the more practical implications of day-to-day life in the justice system of Rhode Island, for example, like the unexplained death of an individual at the ACI. My understanding, he hasn't come to terms with that, but it's good to know that he's weighing in on Hawaii case law. Is something like that potentially a time bomb everywhere? And to what degree is that case law enforceable until it's appealed?
So unless the 9th Circuit en banc issues a stay of its own opinion, which would just basically be, we've issued this judgment, but we're going to stay the ability to enforce it unless and until the Supreme Court decides whether or not they're going to take it. If there is a petition for writ of certiorari, that will be enforceable almost immediately. So, I mean, you had a lot of questions there, so I'll try to unpack what you just asked. There are several gun cases throughout the United States which could potentially make their way to the Supreme Court. This was a pretty big one, however, and I think that the people who support Second Amendment rights were hoping that the panel decision, which ruled that the statute in Hawaii was unconstitutional, would be upheld en banc. Unfortunately, that didn't happen. And I think they're going to, if this does go to the Supreme Court, you're going to see activist AGs like Peter Nerona use the reasoning in this majority decision to say, hey, this is what the Second Amendment protects. It only protects your right to have a gun inside your own home. And, please stay out of my business, which allows me to basically use unfettered discretion to decide who gets a carry permit and leave it at that. And somebody like Peter Nerona, who routinely denies the ability of law-abiding citizens to get a carry permit from his office, is certainly going to point to the rationale used in this decision to justify his broad discretion given to him under the General Assembly statute.
Oof. Wow.
Disappointing, isn't it?
Do we understand much about the makeup of the 9th District? I mean, and again, this is not an area, part of the country that you operate under, so I'm putting you on the spot unfairly here, but they do seem to be notorious. What are your thoughts in that direction?
Well, over the years, the reputation of the Ninth Circuit was exactly how you described it at the beginning, the Ninth Circus, because it was such a left-leaning court that it would often be overturned by the Supreme Court on many decisions, because it was clear that they were imputing political motives into a lot of their decisions. Now, I will say former President Trump did alter the makeup of the Ninth Circuit. It didn't flip the ideology, if you're looking at it from a perspective of which presidents appointed the judges currently sitting on that court, but he did appoint several judges to that court during his tenure, where now there is really a very small split between judges appointed by Democratic presidents and judges appointed by the Republican presidents. However, the Ninth Circuit still has a leftward bend.
Mm-hmm. So, and again, I'm getting into the sort of how this all works. Someone from another district comes up with a different ruling.
Yes.
Is it, you've got the real potential for two different parts of the country operating a completely different criminal justice system, in a sense, if you look as foundational as I believe it is, the right to bear arms. How does that work?
Well, that's, like I was mentioning before, that's one of the things the U.S. Supreme Court will look at in whether they decide to accept a case for review. Is there a split amongst the circuits? Because they want, especially when it comes to fundamental constitutional rights, like the right to keep arms, as the U.S. Supreme Court has already ruled, as far as the keeping arms portion, they want uniform enforceability and applicability amongst the circuits in this country. So I would hope that, considering that at least the Seventh Circuit and the D.C. Circuit have at least ruled oppositely than the Ninth Circuit, that this will hopefully push the U.S. Supreme Court into accepting certiorari in this case, and hopefully putting an end to the dispute among the circuits.
Folks, if you're just joining us, Attorney Chas Calenda from Rhode Island has joined us. He has got an extensive background in the Rhode Island State Attorney General's office in prosecuting criminal law. He is a criminal defense attorney, currently in private practice. He is possibly become the leading, I'll call him, liberty attorney in the state, and that in addition to his normal caseload, he is clearly willing to embrace litigation that involves responses, for example, to the emergency order under COVID here in Rhode Island, works on a day-to-day basis with implications of the Second Amendment, and by the way, is openly considering a run to be the Attorney General for the state of Rhode Island. Full disclosure, we come to him because he's got a pretty unfiltered, unbridled view of the law. We're looking for a discussion of the impact of the law, yes, but we're also discussing, if you will, the construct of the law, as opposed to what so many folks do in terms of becoming activist jurors, activist attorney generals, look to find creative ways to stretch the law. I hope that's a good a good way of picturing it. I hope that's fair, Chas. And again, we respect your ongoing efforts on behalf, if you will, the forces of good here in Rhode Island.
No, I think it's a fair statement, Pat. I try to be as apolitical as possible, especially when I'm looking at the cases which I may evaluate to take on myself. And one thing that I've always stood for, whether I was a prosecutor or whether I'm just practicing as a private attorney, is I am absolutely 100% against government overreach and invading our individual liberties and our constitutional rights, whatever they are. And the rights are the rights. And if we're going to protect one right, we need to protect all the rights. Make sure that the government is not interfering in our ability to exercise our rights.
Right. Absolutely. So right now, if I understand your contention, this is law now. Unless they've decided themselves, which I would imagine would be relatively unlikely, but what do I know? Unless they decided themselves to, in a sense, place themselves on hold. This is the law of the land in Hawaii. You virtually have no rights to carry a weapon outside of your home. Is that where we stand?
Essentially, yes. Once the Ninth Circuit sends the order and certifies the order back to the district court in the District of Hawaii, this will be enforceable. The law will continue to be enforceable. So as far as I know, no stay has been issued on the decision that came out today. So as far as I know, it's in effect. It will be in effect shortly.
Wow. Okay. At what point in time in terms of turnaround, in terms of just, moving the battleship, if you will, steering the battleship, at what point in time will we learn that? And in terms of an appeal process, what are the mechanics of appealing something at the circuit court level? Who pays for it? How does it happen? What's the decisions underlying it? What's the next step?
Well, at this time, I believe it's Mr. Young is the plaintiff in this matter. He's going to have to make a determination of whether he petitions the U.S. Supreme Court for a writ of certiorari, which is a discretionary petition, meaning that the U.S. Supreme Court has discretion as to whether or not they want to accept to hear the case. And they, as you probably know, Pat, they take very few cases that come across their desks for petition for writ of certiorari, and it's paid for by the person who is pursuing the writ. And unfortunately, that is a barrier that not just Mr. Young is going to face, but anybody who goes to court faces, because the American rule, generally speaking, when it comes to legal fees, is that everybody pays their own legal fees. Unless the statute or some other rule of court provides that the winner or the person who prevails, party who prevails, is responsible for the other person's, or the party that loses is responsible for the other person's legal fees. That's the European rule, but the American rule is you pay your own legal fees.
So, if Mr. Young should not choose to pursue an appeal, who would have the standing to do so? Would anyone else have the standing to do so? And maybe you can explain standing to folks, because if I could put it in the common parlance, you don't get to just sue people, do you?
No. You have to have been injured. You have to have or be about to be imminently affected by some law, statute, or some action. In this case, it's a government action to have standing. So, nobody else could really stand in Mr. Young's particular position and petition the Supreme Court to review this matter. There are other people who probably potentially have standing to start at the district court level and try to have the courts hear their particular situations, but you're starting over again. And it's as you can see, this, his denials of these licenses happened in 2011. So we're now talking 10 years where this matter has been winding its way through the federal court systems. So it's not like you walk into court, file suit, and within the next year or so you get a decision on it. This takes years, in some cases decades.
That's probably not the response most of us were hoping for. On TV, it usually only takes 90 minutes. In the movies, it's about 2 hours.
In some cases 58 minutes and about 36 seconds.
Oh. Do you have to be strategic in filing these cases? I'm not going to comment on Mr. Young's situation, but do you, every time an individual brings on or takes on one of these cases, it's, in a sense, it strikes me there's almost an element of the roll of the dice. In this case, we're probably worse off than we were, aren't we?
Certainly in the Ninth Circuit, and in this case, Mr. Young advanced some challenges which I have no idea how they could possibly apply to the Second Amendment. For example, he raised the issue of prior restraint. Now that's a legal issue that usually applies to the First Amendment, where the government tries to prevent the publication of some sort of book or article or news article before it ever gets out to the public. He's basically saying that the sheriffs here exercise prior restraint by not issuing these licenses, and the courts basically laughed those arguments out of court and they were abandoned. So I don't know the strategy that was behind that, but you certainly risk every time you file a lawsuit or bring a matter to court, you certainly risk making bad law. And unfortunately, I think in some ways, this case in the Ninth Circuit certainly reached that threshold.
Again, a simple question here. If you've already got a permit, do you risk the loss of it? I know that's sort of a state procedural issue, but in the broader sense, when the law becomes more restrictive, all of us like to say, well, he's grandfathered in. From your experience, generally speaking, not being a practicing attorney in Hawaii, is that the case?
No, you're not automatically grandfathered in unless whatever law that applies to the situation grandfathers you in. So, I'll talk about it in the context of what's pending in Rhode Island, because I can talk about that a little bit more intelligently than what the Hawaii law is. But right now, as you know, one of the Senate bills is trying to take away the ability of local police chiefs to issue these permits and leave it solely to the Attorney General. Many people, thousands of people in Rhode Island have locally issued permits. I'm amongst one of them. And it would, I think it would, at this point, it would be difficult to take it away from somebody who already has an active permit. But certainly, if that were to pass and become law, it would make it impossible to renew that permit on the local level. So I think once you have the permit, the law in Rhode Island, unless they're going to change this one too, only allows that permit to be revoked for just cause. So I think the people who have that would probably be allowed to ride out the rest of the time of their permits, which are valid generally for 4 years. But at that point, then you're left with no other option, if you'd like to get a permit in the state of Rhode Island, to go see Attorney General Peter Nerona and basically kiss the ring, get down on your knees and beg him, please, Mr. Attorney General, please give me a permit.
If it may please the crown. How did we get, and again, another broad-based, simplistic question. For the love of God, man, how did we get to the point where, I think the term is thou shalt not be abridged, to a point where you've got to literally approach the crown in order to carry a weapon? How did we get there? That's
probably a long-winded answer to that, but we've essentially allowed it, by the people we elect to represent us in Congress, people we elect to represent us in our particular state, and by the individuals we appoint or elect to be judges in the courts that rule us. Their decisions are being made. There are people who have bravely tried to challenge them, but there are also people who can't afford to, or just don't have the time or passion to do so. And little by little, our rights have been eroded in certain areas, and Second Amendment seems to be one of the areas where they like to erode, as opposed to voting rights, where you don't even have to have a reason to vote by mail now. You can just simply mail in a ballot and not show any ID or prove who you are. They want to expand certain rights, which is great, because everybody who's eligible to vote should be able to vote, as long as you can prove that you are eligible to vote. But they're chipping away at other rights, like the Second Amendment, little by little, and eventually we end up where we are, which is we are begging our elected and appointed officials to be able to exercise our rights, which we should never have. That's why this country was formed, to not have to bow before the monarchy, bow and beg before the unelected kings and queens in England to exercise actions which we now consider rights here in the United States.
From your perspective as a very active criminal defense attorney, of all the constitutional amendments, which is the one most under attack right now? The first, the second, the fourth, the ninth? What are your thoughts on that?
Honestly, I'd have to say we're at a point where both, I would say, the First Amendment, freedom of speech particularly, and the Second Amendment are probably at a pretty close tie as to the amendments, which are pretty closely under attack by areas of the government. And obviously only the government can violate your constitutional rights. Private citizens cannot, with the exception of slavery amendments. But those are the two that are constantly, in my opinion, under attack. And right now you have issues with people who have unpopular political opinions, who are being censored, who are being prosecuted, who are being denied the right to hold jobs because of their political opinions or their unpopular opinions. It doesn't even have to be political. That's a First Amendment issue. And you have obviously these cases like Young versus State of Hawaii, where the Second Amendment continues to be chipped away at. And it just seems like the Second Amendment in particular is considered by so-called, and I hate to use air quotes, but so-called legal scholars to be a secondary right as opposed to the rest of the rights that are contained within our Constitution. I don't know where they get that from, but I don't know of any right that's less important than another right.
Right. The right to bear arms in one's self-defense is, in fact, that's a foundation that provides us the freedom to support all the other amendments. And I know for some folks that might sound cliche, but if one were to look around the world right now, one would see unstable regimes around the planet, quite frankly, operating at will because of the absence of any provisions to support the right to bear arms. I also find this ironic, and this will be a little controversial, but let me throw this out there to you. The word insurrection is being thrown out pretty casually these days. Now, you know I'm no fan of Donald Trump, and I'm certainly no fan of the cowardice and chaos that occurred on January 6th. But what I find intriguing is the duality here. That's a nice word for hypocrisy, by the way. On one hand, we've got a media that's having a collective nervous breakdown over the events of the 6th. And I'm not going to debate the importance of the legitimacy of that right now. That's not the point. But they will point out to you that the democracy was in trouble.
That's certainly their justification.
Right. Does it make sense then if, in fact, you've spent the last 4 years caterwauling? I like that word. Got to drop the caterwaul card today. All right.
Good one.
Caterwauling, whining in despair about a totalitarian form of government, and I'll just let that hang out there. That's their claim. Then how would one possibly want to disable and effectively disarm the citizens' response to the very type of, dictatorial powers that they claimed were in effect? How does that make any sense?
Pat, you're telling me there's hypocrisy in politics?
Oh,
you can't be serious. No, you can't be serious. I honestly, I write like you said, I'm not here. I'm not going to defend the actions of people storming the Capitol on January 6th.
Right.
There's no defense to that. But what I will say is that the reasoning that they were having these conniptions over the last 4 years, and then to see them, out there now trying to take away the rights that were conferred upon the people, or they're just really natural rights that were given to people and just codified in the Constitution, like the right to bear arms, to prevent against overreaching governments and tyrannical governments. They're doing everything they can to erase those rights. It's mind-boggling to me. I've stopped trying to figure out the rationale of politicians years ago, because there really is no rationale of politicians other than, how do I keep my power? How do I make sure that others cannot take my power from me, and how do I make sure that I am going to take advantage of any crisis that comes my way to my benefit. So I have very little use for true politicians.
Wow. You are running for Attorney General, or at least you're considering a run at this point. While we've got you for a couple minutes, folks, and if you're just joining us, Chas Calenda is an attorney with a significant criminal justice background, having worked for the Rhode Island Office of the Attorney General as a criminal prosecutor for a number of years, and now works in private practice. And we'll give you a chance, Chas, before you sign off, to let people know where they can reach out to you for all matters legal. We've got a lot of other pressing issues in this state, meanwhile. And one of them, obviously, is the behavior of the Attorney General over the last few months. And it's my contention that folks are still so relieved to be rid of the despot Peter Kilmartin, who literally, I actually have this on in writing, was actually judged to be the worst Attorney General in the history of man. Took focus, took effort, took teamwork, but he has been accorded the title of worst Attorney General ever. So, you've got this reaction to this guy Nerona, who was portrayed as a white knight. And I only met him once or twice very briefly. And my impression, based on the events he was attending, is that he would be looking to modernize our approach to criminal justice, modernize, if you will, our thought process underlying the drug law, which means to work to eliminate it. He would be a breath of fresh air, and now he's being sued by I believe it's a Brown University student we had on the air here. I'm sorry, Roger Williams law student, who we had on the air here, over something as what should be as mundane as APRA law, which is, for folks who haven't done it, is sort of like a FOIA. It's essentially a Rhode Island version of a Freedom of Information Act request. Unable to come to terms with a variety of issues surrounding an assault by a correctional officer at the Wyatt, unable to come to terms with, again, the unknown reasons for, I believe, several of the 4 unexplained deaths that have taken place at the ACI, unable to come to terms with the events surrounding the now infamous moped accident. How's this working out for us, buddy?
You hit on a lot of the important points, which I've been talking about since I announced my candidacy for Attorney General. And, I do know Peter Nerona. I worked in some capacity for him while he was the U.S. Attorney. I was cross-designated as a Special Assistant U.S. Attorney, and I had the opportunity to meet him. And at that time, he didn't strike me as anything other than just a straight-laced prosecutor. And unfortunately, I've been proven wrong since he's taken over the reins of the Office of the Attorney General here in Rhode Island. He has decided that these are his words, that he wants to be an activist Attorney General. He told the Boston Globe that. And he's acted in every way, shape, and form consistent with that title. He's been, he comes on with Gene Valcenti. You see him all the time. Surprisingly, I don't have any invites to go talk to Gene about my candidacy, but we'll leave that aside for now. But I see him all the time on TV. He came out and said, we need to take away the harsh penalties for drug possession. We need to allow more people in the diversion. These are all the right talking points, and many of them I probably agree with. But as somebody who's in the criminal justice system as a practicing attorney nearly every day, I can tell you what Peter Nerona tells the public when he's on TV and what his office is actually doing are 2 different things. And I can tell you why is because the person he has running his criminal division is a person who does not share those specific values that Peter Nerona likes to talk about on TV. I don't know if Peter Nerona himself actually shares those values, but the person he has running his criminal division certainly doesn't, because they've taken away all the discretion from their prosecutors to make their own decisions, to evaluate their cases. And it's pretty obvious when some of the issues you talked about, like the Wyatt issue, the issue involving the gentleman who drove the ATV, and and really the one that you touched on, which if you have a minute, the
go
death
ahead.
in custody at the death in custody at the ACI, the most recent ones, where there is a protocol in place. If somebody dies in custody of law enforcement, there's what they call the Attorney General's protocol. And it involves the Attorney General, the state police, doing an investigation, usually a grand jury. If there's something other than a natural death involved or a suicide, if it's undetermined, if it's accidental, or if it's unknown or homicide, there's a protocol that should be being followed. And the fact that there's a person in their 40s, my understanding is, who recently was found unresponsive and then later died at the ACI, and the death was explained in 3 different ways by ACI officials. And then the Attorney General, who was asked for help by the family, my understanding has been completely silent on whether there's even an investigation going on. I have no explanation for that other than he's either not conducting an investigation or he's doing what he wants to do in a political sense. He's being a politician, not a law enforcement agent. And that's not what we need for an attorney general. And that's really what pushed me over the edge to run to be the attorney general, because I really think we need to take the politics out of these decisions, because you've got too much at stake for people's lives to be worrying about, is this particular attorney general going to follow the law because he either agrees or disagrees with me personally or my political opinions or anything about me. So, that's really what kind of pushed me over the edge.
Well, it's clear that we've got an opportunity here in Rhode Island to engage in a serious discussion about the role, the execution of, and a redefinition of the criminal justice system here in the state through the election of the next attorney general. And it's one we pretty damn much take seriously. I mean, we've got, again, please correct me if I'm wrong. It's probably the 20th time I've said that today. But my understanding of the role of the attorney general is that he is the people's lawyer, if you will. Is that a fair assessment, or correct me on that?
That is a fair assessment. He represents the people of the state of Rhode Island, and yes, he does represent the government when necessary. But his role in Rhode Island, it's a constitutional role. He's not appointed by the governor, and like other attorneys general in other states are. He is elected, and unfortunately, it's a partisan election, which it shouldn't be, but right. It is. But his role, he does not report to the governor. He does not report to any other body other than the legislature, whether if they should try to impeach him for some wrongdoing, which that's, I'm not suggesting he should be, but that's the only thing he's really stands to report to, other than the voters. So right. His role is to support the people of the state of Rhode Island. And I think one of the most important roles as the attorney general is to make sure that people's rights are being respected by the other branches of government. And that would be the General Assembly and the judiciary. There's only so much you can do about the judiciary from the executive point of view as when you're the attorney general. But certainly from the General Assembly's point of view, the attorney general himself has standing to bring action if he believes the law is not consistent with the Constitution. And I have not seen Peter Nerona do anything of the sort.
It's really quite stunning, isn't it? Right now we're looking at a veritable panoply of laws which eliminate elected officials from the day-to-day operations of the government. We're looking at overreaching gun laws which again, infringe on a natural-born right, the right to one's self-defense. And he stands there idly by. Just another day at the beach.
Yeah, and it's not the first time. It's just like his unwillingness to get involved in the federal court case when the mail-in ballots were challenged by certain groups to remove this requirement for a notary and 2 witnesses to be part of the mail-in ballots. I think there were members of the GOP who had challenged the Secretary of State's and the Board of Elections' unilateral decision as a result of that lawsuit to eliminate those requirements. Peter Nerona, state law requires that those 2 things exist on a mail-in ballot. Peter Nerona did not defend state law when it came under challenge. Is that a political decision, or did he just forget to go to court? I think it was a political decision. You can agree with that law or not, But your role, if you don't like that law, you go to the General Assembly and say, change the law. You don't do it by not showing up to court and letting a federal judge essentially temporarily wipe that law off the books so you can get around it.
Right. And that's why elections matter, and elections have consequences, don't they?
Absolutely. Barack Obama said it. Elections have consequences, and they sure do.
Right. It's interesting because on another issue, we've got a state government that, and let's just say a left of center approach, which I actually shared, that had a collective nervous breakdown when his predecessor, Mr. Carmartin, decided to pursue and ultimately pass legislation that allowed for warrantless searches of the prescription medical database, a database that never should have been created in the first place. But, well, it was there, and of course, it was protected for privacy reasons, and no one had anything to worry about. Yet this is the same political elite that, quite frankly, is willing to support the extra legal release of people's medical records in order to, again, here we go again, call me crazy, but maintain the right to bear arms in one's self-defense, which is a natural right, not even really requiring a constitutional defense. There's no end to it, is there?
Not in this state, not in sight at least, not unless there's some radical changes.
Right. Well, you certainly seem to be on that track, so we're gonna continue to have this conversation. I appreciate you joining us at 9:30 on a school night, if you will, after a full and rewarding day prosecuting, if you will, and defending the rights of the oppressed in the halls of justice, a.k.a. Halitosis Hall. It's how do you do it, buddy? I mean, holy cow.
Not easy.
No, it ain't easy being green, is it? Chas Calenda. Chas, we always, as a way to thank you for joining us tonight, we always allow our guests to engage in what we lovingly refer to as shameless self-promotion. So please, if folks are in need of a criminal defense attorney or other types of lawyering, how can they reach out to you and contact you?
Well, anyone who's in need of legal assistance can contact me at the law firm of Inman and Tourgee, and that's in Coventry, Rhode Island. The number is 401-823-9200. Anybody who's interested in contacting me about my campaign to be the Attorney General certainly can reach out to me at my website at chas4ag.com. That's CHAS, the number 4ag.com. Or you can email me directly, and I'm happy to answer anyone's questions. My email is chas, CHAS, at chas4, the number 4ag.com. And I've had a lot of people reach out to me on not only my campaign, but on legal issues. And I'm always happy to answer questions about what I stand for, who I am, what I've done, and where I'd like to go with this, my campaign and my legal work.
You should do a show, you know that? Have I ever told you that?
I think you might have said that to me a couple of times, and I'm always happy to do a show.
Absolutely. Chas Calenda joining us. As we like to say, Chas explains it all to us, to those of us mere mortals who sit in awe of folks who can actually look at those big books and read them and understand them and actually make them accessible to so ordinary folks, as we're getting led down the path to perdition, we actually get it. Thank you so much for joining us tonight.
Thanks for having me, Pat. Nice to see you.
We are the Coalition, loud and proud, outrage porn-free, civilly disobedient media, broadcasting live on the worldwide Coalition Radio Network at coalitionradionetwork.com, facebook.com/the Coalition Radio, on the mighty Twitter at Coalition_radio. Please, if you could take a moment from your hectic, busy day, like us, follow us, share us. Social media is, in fact, the way that we rise above the white noise of the conventional, bored, lazy, feckless, I'll stop, national media. We need your help to get the word out and to give folks like Chas Calenda a platform so that they can educate us, support us, and work for us. Thanks for joining us tonight. Have a great night.